Yo, what's good? I appreciate everybody for tuning in this Friday to this live stream where we're going to cover a few topics. It's going to be a few quick motions before the court. It's going to be a few quick motions before the court that we're going to talk about. As always, my name is Marcus. Here we do attorney reactions to current events and trending news, where we try to talk about something that's entertaining, but we also try to give a good take on it and a legal take on it. Sometimes you get my opinion just as a non-attorney, but we try to make sure we point out the legal nuances. And sometimes we just react to stories because it's just ridiculous. This story has politicians, rappers, correctional officers. It's a wide range of stories tonight, and I hope that you all will enjoy. Definitely aren't going to be here before you long because your boy haven't eaten yet, and I got snacks here and everything. So y'all might see me eat some snacks before my food that I ordered came. Hey, I am a licensed attorney, but I'm not your attorney, so that means that this isn't legal advice. This is just infotainment purposes. As I give my opinion and takes on these topics. If you get some value out of this content, if you hear something you like, if you learn something, if you chuckle, if you laugh with me or at me, if you hate it, hey, either way, I definitely invite you to subscribe, like, share, comment, all of that good stuff. It's a way that you can support the channel, support me, and it's free 99. That's the most important thing. Let's go ahead and dive into our first story. Now, we're going to head up to New York. We're going to go up to New York, and we're going to talk about the Attorney General for the state of New York. If you all don't remember, Attorney General James got national coverage because she was very adamant about going after Donald Trump for essentially mortgage fraud in some form of fashion. Essentially, what President Trump was charged with and ultimately convicted of was overinflating the cost of his assets so he could get better rates on loans. This does happen all the time. I'm not saying that, hey, not trying to take a political take here, but let's just keep it a buck. This happens all the time with people who deal with real estate. President Trump, was charged, I think it was 34 counts or something crazy like that. Well, now things have come full circle, and it looks like Attorney General James in New York is under the gun. Let's dive in, and we're going to talk about it. And your boy know a little bit about mortgage fraud because I essentially investigated mortgage fraud and fraud of government programs related to housing for 2-3 years. So I know a little bit about this area. Let's dive into our first topic. Let's get it.
This morning, a federal agency is asking the Department of Justice to investigate New York Attorney General Tish James. The criminal referral filed by the Federal Housing Finance Agency accuses James of lying on mortgage paperwork to get better rates.
Okay. Essentially, let's just keep it a buck here. We got to be consistent and objective. That is similar to what President Trump was charged with by this attorney general, overinflating his real estate assets to get better rates on loans. Now, the first question we got to talk about is that uncommon for a federal agency to refer something to the Department of Justice? No, it's absolutely not. It's actually the way that business is done. If a federal agency identifies fraud, waste, and abuse, oftentimes they'll refer to that for prosecution to the U.S. Attorney's Office. They can either elect to accept it for prosecution, decline it. If they accept it, they can decide if they want to go criminal or if they just want to pursue civil charges. You see this happen. This is normal course of business for how the federal government works. Agencies or an inspector general for a particular agency, they'll conduct an investigation or audit of a program. They'll find anomalies, and if they think they have something tangible there, they'll refer it to the U.S. Attorney's Office.
News 10 NBC's Haley Higgins has been looking into this. Haley, walk us through these accusations.
Lynette, there are 3 accusations in total. But before we dig in, I want to be clear, these are not charges yet, just a request for the Department of Justice to look through the paperwork and see if there's a case. The first accusation occurred in 1983. It alleges that James, 24 at the time, signed documents stating
Okay, I'm gonna tell you right now, 1983. There's no way I would touch it, even if there was material false information on a loan application or whatever the hell they're about to talk about. The statute of limitation has came and went. There's no way. I can't think of one way where the statute of limitations would be extended or told, essentially paused, to allow conduct from when your boy was barely born or a little kid to even be viable for a criminal or civil cause of action today. So I think this one just off the break is trash, but let's hear what it is.
She was married to her father to get a mortgage. Discriminating against unmarried women had been legally banned 9 years prior to this. The second accusation is in 2001 when the FA.
Okay, real quick, let's talk about that. So that one has a few flaws. Like we said, the offense date was from the 80s. It's just too damn old. So there, even though this was referred, do you think some attorney in-house would have said, this is too old, we aren't going to go down this road? But flaw number one is too old. Flaw number two, even if it weren't too old, which it is, the question would be, was it well, two questions. Was there intent to deceive, to do something criminal? Because it could have been an accident. She could have meant to sign her, I'm not saying it is, but realistically, she could have meant to sign her father's name somewhere else, whether to be a co-signer or to be an occupant, and she signed it somewhere else in the wrong place. That could be possible. So the first question they're going to ask is, was there any criminal intent, even though this is too old to do anything? The second question is, was it a material misrepresentation? How federal law and courts define a material misrepresentation is, was the thing that you falsified so important that you wouldn't have gotten the loan without it? If she would have removed her father's name from her being her husband's slot, would she still have gotten the loan? If the answer is, even if her father's name wasn't written where her husband's name should have been, even if you remove him from the loan paperwork, she would have still qualified. That is not a material misrepresentation, so it's very likely it wouldn't be anything criminal. So we got a few flaws. Intent is an issue. Is the misrepresentation material? Is questionable. But the one that's going to easily knock it out the park is it's too old. This occurred in the 80s. Let's take a look at what the second accusation is.
Been legally banned 9 years prior to this. The second accusation is in 2001 when the FHFA says James described a 5-unit apartment as a 4-unit to get a specific government loan.
Again, I think it's too old here for anything criminal to be viable. Generally, the statute of limitations we talk about all the time for criminal offenses is 5 years. It would be a false statement. A false statement can be written, or a false statement can be written on a government document or on a documentation going to a government entity. It could be a false statement to a financial institution if it's trying to acquire or get a mortgage. Either way, 2001, you're talking about over 20 years old. Definitely not viable. Nothing is probably going to happen with this one from a criminal or civil standpoint. I wouldn't take it.
The third in 2023 says James bought a house in Virginia.
2023. All right, now we cooking with now we working with something. Okay. 2023, relatively new. This one may be viable. Let's hear what it is. Then we're gonna break it down and dissect it.
James bought a house in Virginia and said it would be her primary residence to get better rates. State laws demand James mostly live in New York, so this should have been considered a secondary home. And James bought that Virginia home months prior to bringing a civil suit against President Trump for fraud. That suit alleged he inflated the value of his properties to get better loans. The FHFA, the agency highlighting this, is responsible for supervising federal loans. FHFA Director William Polt was appointed by President Trump and sworn in last month. We reached out to the Attorney General's office for comment. A spokesperson said this referral was, quote, weaponizing the federal government and a bullying tactic.
Thank you, Haley. Turning to the referral now, how common are these criminal referrals?
Our affiliate in Buffalo actually spoke with a former New York Attorney General who said they happen frequently. It's just a
See, I said that. I didn't even watch this whole video. They happen frequently.
recommendation to a prosecuting body. But former AG Dennis Vacco did highlight, though, they're usually not released publicly and they don't come out unless the charges are filed.
All right, Haley, thank you.
Okay, so I do agree with that statement. With that last cause of action, it's still right. It could be an issue there. It occurred in 2023. So you're looking at probably around until 2028 where viable criminal charges can be brought. It's actually an interesting issue because in order for her to maintain her position, her principal residence, her domicile has to be in New York. If she's saying that her principal residence is in Virginia, you either give up the seat or you move to Virginia. It's weird. I'm gonna be honest. With this one, you would have the same issues. Was there an intent to do something criminal or to deceive? Did they have criminal intent? Was it a material misrepresentation for something? Where is she paying taxes? Did she put this as her principal residence or primary residence? Was it material? Was it an accident? Was it an error? Is she paying taxes in New York? Those are that she has a majority of her foundational things, bank accounts, families, kids in school, or those things in New York. Those are the things that are going to be looked at. I'm just going to be honest. If I'm prosecuting this case and this land in my desk, number one is out because it's too old. Number two is out because it's too old. Number three, it's kind of not a big deal, really. I don't know what evidence they may or may not have for materiality. I wouldn't waste the resources looking into this, but the misrepresentation of the home as a primary residence, like the rooms from 5 to 4, I would probably institute some type of civil fine to make sure the back taxes or penalty or something was due, and I would just let it go. I don't know. This regime may want to move forward on it, and they reserve the right to, because if they can prove intent, it could, in fact, very much be criminal. But that would be my take on how I would resolve that one. All right, let's go ahead. We're going to pivot to our next story. This story is actually interesting because, hey, it's some people on this channel who say that, man, I see you one of those people who like to talk bad about black folks. Yes, I like to talk bad about black folks who are doing things illegal and wrong. I like to talk bad about plaid folks and white folks. And if you're doing something wrong, I'm probably going to talk about it. If you caught up in a legal story that's interesting, I'm probably going to talk about it. But this next story is interesting. We're going to look at 10 correctional officers who've received a multitude of federal charges, high as murder. We're going to dive in and check out this video. Let's jump in.
Disturbing and graphic details have been released in how mid-state.
We're gonna skip to where the pertinent information is. I thought I already had it set. But we're gonna skip to where the pertinent information is.
The ones who used to hold the keys wore the cuffs into Oneida County Court Wednesday, charged with crimes ranging from manslaughter and murder.
Not an intentional murder, but a murder so depraved and so wanton and disregarding of human life that New York law allows it to rise to the level of intentional murder.
All right, real quick, they got a special prosecutor on the case. Why is there a special prosecutor on the case? Think about it. Most states, the Bureau of Prisons fall within the Department of Justice, so it could be a conflict for a state attorney general to prosecute these guys. So normally what they'll do is they'll bring a prosecutor in from another county who has no ties or nexus to anyone in this Bureau of Prisons to try to keep it fair and impartial, keep it looking unbiased.
To gang assault and conspiracy.
On the following morning, at a diner called Raspberries in Oneida County, all of the co-conspirators met and agreed to continue with the story that everything they did was completely proper.
The special prosecutor says 10:55 a.m. March 1st, Midstate Correctional Facility inmate Messiah Nantwi was fine, and by 10:58, a radio call was made for backup and a CERT team response. Special Prosecutor Bill Fitzpatrick says the grand jury in this case suggests It's something that spiraled out of control unnecessarily.
All right, just so y'all know, the SORT team, some places call it the SORT team. That's just the team that they call out in prison when things or jails, when things get a little out of control, is when the COs put on all their armor, they get their shields, their batons, they go in there, possibly ready to crack some skulls because there's something that requires them purportedly to actually be there to eliminate some type of threat or danger or harm to another officer or another inmate or something to that effect.
The alleged contact that began between the National Guard and Mr. Nantwi had to do with Mr. Nantwi interjecting himself in another incarcerated individual's effort to obtain medication.
Some of the 10 officers charged in Mid-State Correctional Facility inmate Messiah Nantwi's death are accused of beating him with their fists, boots, and batons in the head, delivering 69 blows to his body alone, continuing the assault in a stairwell on the way to the infirmary, and
That's ridiculous, bro. 69. Come on now. That's ridiculous. Like I'm about as fair as it come, and I understand that sometimes in some situations you got to use a little bit of force to be able to eliminate threat. But when you have, and again, I get it too. It's jail, prison. It's not Club Med. I understand that part of it, but some shit is just overkill. And just off of what we're hearing from this, it sounds like overkill.
dumping the 22-year-old in a holding cell in the infirmary and continuing the assault there with a conscious effort to cover it up.
Fragments of Mr. Nantwi's entrance into the infirmary are captured on one corrections officer's body-worn camera. It is not a continuing flow, but there are enough indications to name and identify the individuals involved and some of the things that occurred. Many other corrections officers, apparently intentionally, either turned off their cameras, placed them in an area of concealment, or simply looked the other way.
They all screwed. They all about to get exactly what's coming to them. When we talked in that last video about did someone have the requisite criminal intent, the mens reis and the actus reis, all of this stuff. Yes, this actually shows an intent to either commit a crime or conceal a crime. Bruh, y'all got on body worn cameras. When you try to cut it off, when you try to obstruct it, it's just not a good look. And it goes to show that you have something nefarious going on. So I hope all 10 of these guys get exactly what's coming to them.
After the deadly assault, Fitzpatrick says, came a plot to plant a weapon, a plot that was caught on tape.
A body-worn camera intentionally hung in a men's room at the infirmary of Mid-State caught two of the co-conspirators discussing the conspiracy to plant the weapon, again, posthumously on Mr. Nantwi.
From the state corrections commissioner in Utica today, acknowledgement and a promise to do better.
The people entrusted to our care deserve better than this. We hired external law firms to conduct a full review of the system, which is currently underway.
Not in court today, 6 others who are cooperating with the special prosecutor, 2 of whom are pleading guilty to felonies, 4 to misdemeanors. The 10 officers in court today are due back in Oneida County Court through May to report on plea offers. Those for whom bail was set posted bail. Jolene Ferris, News Channel 2.
This is a beautiful instance of the justice system clearly working out. And it happens all the time. I always want to see the right outcome. I think the facts in this, just what we got from this news story. And again, this is the first time I actually watched that news story all the way through. It clearly shows an intent. It clearly shows conspiracy where they came together, more than one person, in the furtherance of the commission of a crime. They took a substantial step towards the commission of that crime. They were able to use some leverage because they do have people who are entering pleas to misdemeanors and some lower level felonies who are snitching and telling. That's a beautiful thing. And shout out to body worn camera footage. A lot of people get mixed reviews with body worn camera footage. Some people are like, oh, we need it. Some people we don't. I'm always a fan. I think body worn cameras should always be used by law enforcement just to memorialize the interactions. This goes to show you how dumb these guys were and how slick they thought they were. You're having a conversation about potentially planting a weapon on the decedent in an effort to make your story seem more plausible and to corroborate the lie that you're about to tell. So shout out to the justice system. I hope these guys get everything that they deserve, everything that they have coming to them, because they were ridiculous. Now we're going to take a little bit of a pivot and jump and talk about immigration. Immigration is a big issue. We got the border czar doing their thing. We got Kilmar Abrego in Venezuela. The Supreme Court saying, get him. Is the Trump? It's a big deal. But this story is interesting because I think we all have to agree, whether you're a Republican, whether you're a Democrat, whether you're, whatever, donkey, elephant, camel, giraffe, blue, red, purple, fuchsia, no matter which we all have to, this channel is good for debate. We can go back and forth over topics, but we have to accept some things as actually being true. If a person is in the United States and they are here without the proper documentation, that in and of itself is a crime. If we can't agree on that, we can't even have the debate. It is a crime according to the laws. Now, some may be more egregious than others. You can have a person here who's not here lawfully and they have a criminal background and all this stuff. You can have a person who's not here lawfully, who worked for 30 years, paid into the SAC system. It can cut both ways, but we have to agree on what a fact is. Like me and you standing outside, if we look up at the sky and can't agree that the sky is blue in the middle of the summer, we can't have a discussion about anything else. That's what we have to realize here, that if a person is here without the proper paperwork and authorization, that in and of itself is a crime. Let's take a look at this judge, what her behavior was when it comes to, I guess, upholding or more importantly, violating the law. And we're going to talk about it because this is an interesting story. Let's jump in. Let's get it.
National headlines emerging out of Milwaukee today. FBI agents arrested a Milwaukee County Circuit Court judge at the courthouse. Federal investigators say Judge Hannah Dugan helped an undocumented migrant avoid immigration agents trying to arrest him. 12 News cameras captured Judge Dugan leaving through a back door at the federal courthouse, now charged with 2 felonies. The judge's arrest sparking a huge protest today. We have live team coverage of this breaking story. 12 News' Nick Bohr at the Milwaukee County Courthouse downtown. Nick, that's where the FBI arrested the judge shortly after she got to work.
Now, again, these videos we watching today, outside of the ones about our main story, Lil Durk, and how he has a great chance of getting a dismissal, I haven't watched these stories. They were sent to me. I was like, you know what? These will be good. We'll check them out. How insane is this? If she's been arrested, so there's already an indictment. I didn't want to go through the indictment. I may go back and look through it because it actually might be interesting to look at. But a judge allegedly helped an undocumented migrant avoid the capture of Homeland Security by Homeland Security. That's actually insane. Like, I don't know. Was there a familial relationship? Was it her baby daddy, her boyfriend? Was she doing this out of the kindness of her heart? I got questions now. I may actually have to go look at the indictment. But let's finish checking out the story before I go too far.
Right after she arrived outside the courthouse cafeteria here, inside the courthouse on the ground floor. A short time later, as you said, she was in federal court for a hastily called hearing. I was there. Cameras are not allowed inside that hearing, but she was escorted in leg irons. Her ankles were shackled, connected by a chain as she walked into and out of court. Hannah Dugan has been on the bench for 9 years, seen here at an event for voting rights. But she's now thrust into the national spotlight for an incident 1 week ago at her courtroom in the Milwaukee County Courthouse.
Judge, anything to say about this?
Dugan hustling out a back door at the federal courthouse.
You've been on the bench for 9 years. I got so many. Let's finish playing it because I'm about to. This is going to be interesting.
Where cameras aren't allowed hours after after her arrest. Federal prosecutors claim Dugan learned immigration agents were waiting outside her courtroom to arrest 30-year-old Eduardo Flores Ruiz last Friday. He's a Mexican national charged with misdemeanor battery in Milwaukee and was out of custody. According to the federal criminal complaint against Dugan, after a hearing in Flores Ruiz's case, she helped him leave court through a private hallway. A witness telling FBI agents he, quote, saw Judge Dugan get up and heard her say something like, "Wait, come with me." Despite having been advised of an administrative warrant for the arrest of Flores Ruiz, Judge Dugan then escorted Flores Ruiz and his counsel out of the courtroom through the, quote, jury door, which leads to a non-public area of the courthouse. When I talked to
Yo, I hope they throw the book at this judge. I hope they throw the book at this judge for what she did. I don't even know why she did this. She's clearly, I'm assuming this guy wasn't her baby daddy. It wasn't like he had no other value to her outside of being defendant in her courtroom who was there for what sounds like a misdemeanor at the state level. This judge needs to have the book thrown at her. I guarantee you, I know who she didn't help. She didn't help anybody charged with a assault on a female get out and escape any potential federal warrants. She damn sure didn't help any person who was charged with drug distribution who may have had a federal warrant and was on the verge of being picked up. Like, yeah, this lady is absolutely terrible. She must be one of them extremely liberal, like I'm talking about super liberal, like outside hugging tree type people, because this is actually crazy.
Judge Dugan here Tuesday, she didn't want to comment on the issue a few days earlier inside of her courtroom here. The doors are now locked. She's not hearing any cases, at least for now. The Milwaukee County Executive says it's critical that the courthouse remains a safe place where rights are protected.
We're having a lot of conversations with many of our partners. I don't want to put too much information out there, but we're looking at every avenue that we can as it relates to protecting people's due process in this bill.
Dugan was released on her own recognizance, but is charged with 2 felonies, obstructing a federal agency and concealing an individual to prevent his arrest.
Right.
And Nick's live with us again. Nick, federal agents eventually arrested Flores Ruiz that same day.
Right. There were actually 6 federal agents in the courthouse that day for his arrest. One of them.
We're looking at every.
Let me rewind this back.
Having a lot of conversations with many of our partners. I don't want to put too much information out there, but we're looking at every avenue that we can as it relates to protecting people's due process in this bill.
Dugan was released on her own recognizance, but is charged with 2 felonies.
Okay. Let's forward back to the end of this story, because this judge is ridiculous.
Right. There were actually 6 federal agents in the courthouse that day for his arrest. One of them did spot him in a hallway and followed him outside here, where they had a foot chase that went all the way down to the corner here on State before he was arrested. He remains in custody. Judge Dugan out of custody now, as we saw there. Her attorney, former U.S. Attorney Stephen Biskupik, saying today Dugan, quote, will defend herself vigorously and looks forward to being exonerated.
Nah, bro. I'm not feeling it. I'm not even feeling the county executive who was standing up there and he was talking about, we're going to make sure we do every effort to ensure that due process is followed. You can't even say that because you don't know if now, will he be afforded due process? I don't know, but you can't preemptively say we are going to commit a federal crime by hiding and evading federal law enforcement authorities because we don't know if this guy is potentially going to get his due process. I just don't think a judge who's been on the bench for 9 years should be smart enough to know that there's a better way to try to resolve this. You could have called a buddy who was an immigration attorney. You could have did a plethora of other things besides trying to sneak this guy out of the an area of the courthouse that's not for public access and evade federal authorities. So shout out to you. You deserve the offenses that you got. That gentleman is in custody and he will get processed, and hopefully he does have his proper due process, and you will get processed. And I don't know how you anticipate being exonerated, because I don't know. I see intent clearly there. Was it obstruction of justice? What? everything that they charged you with sounded about right and about accurate to me. Y'all let me know what y'all think. What y'all think in the comments. Am I being too Republican on this one? Like, I'm pretty much a neutral guy. I'm pretty much a in the middle guy. But this is absolutely ridiculous, and this judge actually should be disbarred for this conduct. She is charged with a felony. Once she's convicted, she actually, if you're making a decision to do this as a judge, I question your ability to objectively discern the facts and evidence before you and make the proper legal ruling. That's just me. That's my take. Y'all let me know in the comments. Am I being too tough on this one? Now, excuse me. All right, now we about to jump into our cover story about Chicago rapper Lil Durk, who is currently in custody. Let's take a quick look at this video. It's less than a minute long, just to give you some background on why Durk is in custody. Durk Banks, aka Lil Durk, is in custody. Then we're going to talk about his chances at a dismissal. I'm going to be honest. His defense counsel made a very good argument, very articulate, very sound, based on facts and law. I think he has a very strong chance. Now, I can't say it's probably the best argument that we've reviewed on this channel made by a defense attorney. I didn't even look up on the pleadings who the defense attorney was, but a round of applause to them. If you're from Chicago, if you're watching this, hey, your defense attorney did an outstanding job. A lot of times, these celebrities pick attorneys who screw them over. I'm not going to name no names, but Shannon Sharp, terrible attorney. This guy who wrote this brief, I am thoroughly impressed. I read it and I was like, they did their homework and their due diligence, and they brought facts and evidence to back it up. I'm not saying Durk going to be home soon, but I'm saying, hey, this could potentially be very favorable for his defense in his case. Let's go ahead, jump in, and see why Durk is in custody. Then I'm going to jump into my notes.
Well, police arrested Grammy Award-winning rapper Lil Durk in Florida on federal charges that he paid for the attempted 2022 revenge killing of another rapper at a Los Angeles gas station. Investigators are saying the shooting was aimed at Quando Rondo. Rondo's cousin was killed instead. Durk is charged with conspiracy to commit murder for hire. FBI records show that Durk and 5 members of his Chicago-based rap collective Only the Family, or OTF, have also been arrested. Durk, you might remember, won a Grammy this year for Best Melodic Rap Performance for his song All My Life.
Okay.
Well, police arrested Grammy Award.
Pause that. Let's get out of here. Let's jump into the notes. So we know that Durk Banks, aka Lil Durk, Chicago rapper, drill hip hop scene, O Block representative. So he is charged criminally in alleged murder for hire. The interesting thing that's going on here, and sometimes you're gonna see I'm gonna be skewed over here because I got my notes. I like my notes on this screen and not on this screen. Now, the interesting thing here is we're going to talk about is self-snitching in song lyrics. People snitch and tell on themselves all the time in songs. Even worse, people go on podcasts and talk about all the shit that they done as if no one is listening. I'm going to give Durk a little bit of credit here because I think Durk is a relatively sharp guy. I've seen him in interviews where he's made gestures to ensure that other people in his collective didn't say anything that would be going a tad too far that can open them up to criminal exposure. Hey, I'm not saying I'm supporting the commission of crimes or alleged crimes or anything like that, but I think that this dude he's very savvy about what's being said and what's going on around him. I definitely don't think this guy's a dummy at all. I'm just saying, I've seen artists go in interviews and say things in songs, mostly go in interviews and just destroy themselves. We talked about it with Big U in his video he did when he was turning himself in. He admitted to like the commission of potentially 2 crimes just by live streaming before he was going to turn himself in. No, don't do that. But I think this guy's very sharp, and I think he's very cognizant as to what's going on and what's being said around him. But we're going to take a look at song lyrics. In this discussion, his lyrics in a song are being used against him as proof, and that's what we're going to focus on here today. Now, this is interesting. The defense is arguing that Durk recorded the lyrics that's being used against him before the alleged murder for hire plot came into existence. So the only way that it could be used as evidence against him is if Durk had a time machine and can go back in time. But the prosecution is saying Durk made this song where he talked about what he was going to do. He talked about this purported alleged hit that was going to happen on Quando, and then it actually the prosecution is saying that the hit happened, and then after the hit happened, he made this song bragging about what he did. He made revenue off this song, boasting and bragging about what he did, this hit on Rondo. That's what the prosecution is saying. The defense is saying, like, no, that's not what happened. Durk made this song, and then, which he has a First Amendment right, freedom of speech to make. Then 7 months later, Quando Rondo ends up having this alleged assassination attempt. His cousin passes away. Has nothing to do with my client. Now, this is interesting because a motion to dismiss has been filed. So they're filing for a motion to dismiss, but here again, his attorney has done something that's actually genius. You always plead in the alternative. If I'm asking the court to dismiss, I need to give the court another alternative to do if they don't want to do my dismissal. So here the defense is saying, hey, we're filing a motion to dismiss. Or in the alternative, judge, if you don't want to grant our motion to dismiss, we are asking that you authorize the release of the information that shows what the government provided to the grand jury to get this indictment. Now, why is that interesting? Because originally a bunch of people were indicted for this alleged assassination attempt on Quando Rondo, but Durk was completely left off. Durk was not even in the original indictment. He was mulled around as a person of interest, but he wasn't on the indictment. They had a superseding indictment that came. So the reason that they're asking for either a motion to dismiss or to release the information about what the government provided to the grand jury for them to get this indictment is key, because whatever the government provided to the grand jury to get the indictment is what actually got Durk caught up in this mess, because he wasn't in it originally. And the defense is saying if the government told the grand jury that Durk committed this alleged murder for hire plot, then made a song about it, if that's what the government told the grand jury and got the indictment, but it is true that the song was made before this alleged assassination attempt, murder for hire plot occurred, it's false. The grand jury, the true bill shouldn't be held. It should be dismissed because they got an indictment based on false information. So this is actually a beautiful argument. I don't know if you all see how beautiful it is, but I'm really excited about it because I like good attorney work. All right. So after the death of King Von, Durk allegedly ordered a murder for hire on Quando Rondo because Durk believed that Rondo had something to do with the instigation, the gaslit that led to the situation surrounding King Von's death. Now in 2022, Durk received word, according to the prosecution, that Rondo would be in LA. So he organized members of his OTF collective to travel to LA and target Rondo. The feds are alleging that OTF, only the family, his music collective, is a criminal organization. The feds believe that Durk's right-hand man, Kevon Graham, secured the cars and the alibis for the hit. Now, the court filing in this case, and I was going to pull it up to show, but I was like, nah, I don't like showing certain things with pistols. YouTube get a little funky. But court filings show photos and images of Quando Rondo's SUV being followed by a white sedan. It also shows images of the actual shooting as it is occurring in broad daylight in the middle of a busy ass daytime public place near a gas station, which is crazy. Now, if you're familiar in the hip hop game, Rondo ends up surviving, but his cousin, rest in peace to him, ends up passing away. Like we said, initially, Durk was not a defendant. He was a collaborator, ID'd as a co-conspirator. However, a superseding indictment came and it named him as a defendant, and they charged him with conspiracy, the use of interstate facility to commit murder for hire, resulting in a death. All right. Now, the feds also alleged that they have information that Durk did text to members of his collective who they believe were a part of this murder for hire plot. Don't book no flights in my name. And Durk offered a substantial bail package, but because of the nature of the offense, because of his resources, because he could be potentially seen as a flight risk, because think about it, no judge is going to give somebody a bond if they're being held for potential murder for hire. Witnesses can end up dying. It could get crazy. So Durk and his team of attorneys did submit a bail package, but it was denied. Now, self-snitching. Now, I hate when media broadcasters do this. They read a rap song, they read lyrics on TV, and you're like, this dude never heard a rap song in his life. I know who Lil Durk is. I got some of his songs on my playlist. I got some of Von's stuff on my. I know who these people are. I've never heard this song, but we got to talk about, is this self-snitching or is this freedom of speech that just happens to foretell an event that occurred that was random? Now, the rap song Durk was a feature on, it was with a rapper named Babyface Ray. Durk rapped about, allegedly, according to the government, Durk rapped about SR's death on this recording. Now, I'm going to read the lyrics, and I'm going to sound like every news reporter who is on the news, who don't listen to hip hop, who's trying to quote some lyrics. But I never heard the song, so I don't know the cadence. But told me they got a natty, go, go, go. Location, go, go. Green light, go, 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 go. Look on the news and see your son, you screaming, no, no. Prosecutors are alleging that those lyrics in the part that says no, no is referencing Quando Rondo's reaction at the time that his cousin's body was removed from the SUV. Now, we are going to show this video. It is blurred out, so it's not going to be too crazy or nothing like that. But I want y'all to see what prosecutors are talking about. Again, the prosecutors are saying that these are the arguments. The prosecution is saying that, hey, Durk committed a murder for hire, allegedly, and then he made a song bragging or boasting about it. The defense is saying, no, this song was made 7 months before this murder plot even occurred. So we're asking that the charges should be dismissed. Or if you don't want to dismiss the charges, Judge, we need to know what evidence that the government provided the grand jury to get the indictment. Because Durk was not a defendant, then the government showed him this information, and now he's a defendant with an indictment. If the government showed him this information and it's false information because the song was made before the alleged murder for hire occurred, the indictment can't hold. It has to be tossed out. The grand jury got an indictment with information that isn't true. Now, again, with the lyrics, the prosecutors are saying that the no, no, no part in the song is referencing Rondo's reaction after his cousin's body was pulled from the vehicle. Let's just take a look at that clip real quick. Short clip, super short.
Shots fired, a fight taken to the streets, and this chaotic scene, the ending of a shooting that started in Beverly Grove. Sheriff's deputies pulling out a man who had been shot in an SUV. This man, a passenger in that car, frantic.
Okay, so you all saw the video. That was Quando in the black. They were pulling his cousin out, and he screamed no, and Randolph screamed no again. The lyrics again, because I want to make sure y'all got all the information. Told me they got an addy, go, go, go. Got location, go, go. Green light, go, 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 go. Look on the news and see your son, you screaming no, no. And also, the feds allege that in the song, there's audio of that video we saw, that sound bite uploaded to the song as well. So this is actually an interesting story, I think. Now we jump into the attorney analysis part. This is the fun part. Okay, can the prosecution use lyrics against you? Yes, they can. We've seen it happen a lot. Probably one of the most famous ones is the YSL case, which is still going on. The young thug ended up pleading guilty. He got time served, but it's normally not persuasive and it's normally not successful. Using lyrics have never been the sole reason that someone was indicted, that someone was convicted of a crime. Even with the YSL trial, I don't think anyone would say that trial was a successful. Most of the people they prosecuted were not convicted, so it definitely wasn't a success. Now, like I said, the defense also has a freedom of speech argument that, my client can make a song about whatever he wants. He is making a song about the reality that he's seen, the environment that he grew up in, and it's about people who get shot. And unfortunately, people get shot all the time. Now, again, Durk's attorney is saying that this song was released before the murder. So that's key. If the song was released after the murder and this evidence was used to get the indictment, the government will be good. If the song was released before the murder, but the government told the grand jury it occurred after the murder, he should get a motion to dismiss, just on a true bill. All right. Now, we talked about this before in yesterday's video, authentication. You can't just admit evidence into a court of law. Hey, this is DFD. This is me on the phone talking about how I'm doing some wild cowboy stuff, and we just submit it. No, it has to be authenticated. So we have to prove that, is that my voice? Did I make that phone call? Has it been edited? What has the chain of custody been? Was it manipulated? Is it AI? Is it a deep fake? We have to prove all these things. So, one, for the defense, well, essentially, let's scratch that. What the prosecution is going to have to show to authenticate this is essentially someone being able to say that, hey, this was Durk. I was in the studio when he actually recorded this in the booth. I know that this was him. This is his voice. Normally, it's going to be a producer. They have other people tied up in this. If one of those other persons who were indicted before Durk was indicted was in the studio, one of those co-conspirators may be leveraged to see if they can testify to being in the studio at the time that this was recorded. Two, for the defense, it's really difficult because I don't know how they can confirm what the lyrics were about. Unfortunately, I've seen victims of gunshots, been there live and in person. It's actually common that people scream out, no, 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 in that stressful environment. So it's going to be very difficult. But in order for the prosecutors to authenticate it, they're going to have someone who actually can say that, yes, I saw Durk as he was recording this song. Then they would potentially be able to get this admitted in the court. But there are a shitload of holes in the prosecution's theory. Now, the government's motion to dismiss. The government is arguing, the defendant's motion to dismiss, sorry. The defendant is arguing that the government presented false information to the grand jury as they said that Durk committed this crime, then he made this song where he celebrated and made money bragging on his murder for hire. That's the government's argument. The prosecution is saying, the defense, what the fuck? The defense is saying, no, the song was made prior to the attempted alleged murder for hire plot even occurring. This misrepresentation is a material misrepresentation if the government said that this song was made after the killing and it was really made before. And if that is true, the grand jury got false information and his motion to dismiss will have to be successful. His defense is saying the court should dismiss the information based that the government either knew the information was false, that they learned the information was false and didn't change or adjust it or dismiss it on their own, or that they had a complete disregard for whether the information was false. They didn't even do their due diligence to research it. And I think it could be definitely 1 and 3. It could have been all 3. It could have been that they known it was false. It could have been that they learned it was false. It's probably more likely 2 and 3. But I think this is a very strong argument. Now, if I'm the defense attorney here, I'm going to focus on the misrepresentation. That's the number one thing. It's the timing. And the question is, was the timing presented to the jury? Remember, an indictment happened and all of these guys from OTF got arrested. Durk was out. They went back to the grand jury with new information. In that information was something about this song where the prosecution said Durk did this shit and then he made a song bragging about it. The defense is saying this song was made before this incident happened. And if that is true, the grand jury pulled the indictment and got an indictment on Durk based on false information. All right. So the question is, if this is true, let's say this is true, the question you have to ask is, could one piece of evidence cause an indictment that was a true bill by a grand jury to be tossed out? The answer is it depends. Right now, the grand jury is a secretive process. Nobody knows what goes on with the grand jury. Nobody knows what goes on behind the scene. They want to protect the grand jury at all times because it's a sensitive part of the legal process. And I understand that. But this is going to be the kicker. If multiple pieces of evidence were used, let's say the prosecutors said, yeah, Durk did this shit. Then he came out with this song and was bragging about it. In addition, we also got this testimony, this video, these text messages, all of this other stuff. If the prosecution presented 10 pieces of evidence to the grand jury, and out of those 10, one was this song, and it's actually proven that the song was made before the incident, chances are the indictment will stand. The motion to dismiss won't be successful because the grand jury didn't only rely on this one piece about when the song was made. They relied on 9 other pieces of evidence, text messages, testimony, geo-tracking on the cell phone, all those other things, hypothetically, right? But if the only information that the grand jury got to indict Lil Durk was based on this song, was that, hey, this guy committed this crime. We have him committing this crime because we have a text message of him saying, don't nobody get no flights in my name. And then after he committed this alleged murder for hire plot, after that plot, he made a song bragging and boasting about it. If that's the only information presented to the grand jury and the defense can prove that the song was made 7 months before the murder occurred, Durk has a great chance of getting a W and getting out of this one. We talked about the First Amendment argument. The prosecution essentially is going with Durk made a statement against his interest in this song after the fact, and we're going to use this against him. Now, remember, if the government was wrong and bungled this time frame, one, they're extremely stupid and incompetent. The other thing is, how could the government make this mistake? How could you hear a song and not know when the song was made? How do you not know the date of the offense, the date that the song was made? And how could you potentially confuse them if that's true? Well, I'm going to just be honest. Most prosecutors in the country probably aren't listening to hip hop. They probably aren't up to date on what's going on with OTF, Vaughn, O Block, all the beasts with 63rd, 64th, 65th. They probably actually have no clue. They probably don't have, they potentially have no one on their staff who can listen to rap lyrics and actually tell them what the hell that they're actually saying. Hey, sometimes in those prosecutor rooms, I know for most of my time at my current job, I was the only brother there. I was happy when we got another brother. I was like, hey, how's it going? We're going to be friends, man. But a lot of times they don't have anybody in positions who know about the hip hop culture. They can listen to a song and the song could be talking about anything. And these people are so untuned to what's going on in the culture, hip hop, how slang is used in different geographical areas. They just don't know. So the question is, how could the prosecution potentially bungle the date of the offense and the date that the recording, the audio was made, the song was made? Because it was probably a bunch of potentially older white guys or people who just don't listen to hip hop. If you listen to country music, you're not going to know what the hell these guys talking about. And vice versa. If I listen to a country song or some slang from Arkansas, Alabama, I might be like, what the hell are they talking about? I may have no clue. All right. So again, the defense is certain that Banks wrote the lyrics 7 months prior to the killing. Okay, now this is what the prosecution is also saying. Okay, the government has to have done one of these three things, and if any of these three things are done, Durk should win his motion to dismiss, and he should be free to go. The government knew that the information on the recording was false. And we're going to talk about this recording because they brought receipts. I love receipts. The government either knew it was false or the government did not know it was false, but the person or witness who gave them the information knew it was false, or the government learned it was false, or the government just disregarded that the evidence was false and moved forward. If the court is uncertain whether the false information the government presented to the grand jury was, if they don't know that it was true, they would have to dismiss. Or an alternative, court, if y'all don't want to dismiss, you have to let us know what the government gave the grand jury. I think we need to know what evidence the government gave the grand jury in order for them to come back with this indictment against Lil Durk and get him added as an actual defendant. Here's going to be the kicker. If it's dismissed, that's easy. I don't think the judge is going to dismiss it. I think the more likely scenario is that the judge is going to allow the defense to get information about what facts was presented to the grand jury to get Durk indicted. If the only thing that the government presented was this audio recording where they say Durk killed this guy, set it up, and then bragged about it by making this song after, and that's not true, Durk is going to walk. If the government presented 10 pieces of evidence and that song was only one, Durk is probably going to stay put. All right. Now, let's talk about this video, because this video is actually interesting. This is how ridiculous the government is. In this case, the video that was made where this song is there, where they're saying that this is Durk bragging about his murder for hire, this video was not posted on any official website associated with Durk. It wasn't posted, on any official website posted with his collective OTF, with his stablemates, none of that. They appear to be posted on fan pages on social media. Bro, this prosecution is ass. His attorneys are doing a bang-up job. So, again, Durk did not create these things, is what they're saying. And these songs that you're referencing to get this indictment weren't even songs that were authorized by my client, Durk. They weren't even authorized by OTF. They weren't authorized by the label. This is something that a fan is doing. And we know all the times fans will make songs, fans will remix it. They'll add AI to make it look like a video. Now, this is the kicker. The defense for Durk has two witnesses, two producers who are willing to testify on the record in the affidavit. They've already done so, that the song was made prior to the shooting actually occurring. The first one is Justin Gibson. And I'm gonna pull this up on the screen now because I want y'all to see what Justin Gibson said. We're gonna share screen, window. I don't like showing my notes, but I'm gonna show them for purposes of this. All right. It says on January, this is Justin Gibson, the producer, who's saying that I was with Durk in the studio when he recorded this song. This song was recorded before the shooting occurred. On January 25th, 2022, I had a recording session with Mr. Banks where we recorded the song Wonderful Wayne and Jackie Boy, which at the time we called Too Toxic. I loaded up the song around 5:39 p.m. Mr. Banks then wrote the verse right there in the studio, and we recorded the song and finished in less than an hour. Once we were recording the song, I bounced a rough draft, saved a copy of the audio format, and named it Toxic Babyface featuring Lil Durk at 6:33 p.m. After that, we continued the rest of the session. So this guy said, I was there with Durk. I saw everything. We recorded this before the shooting occurred. Let's take a look at Ahmad Sharif, the other producer, and let's see what he said. It says, I received Durk Banks' verse and lyrics for Wonderful Wayne and Jackie Boy from Justin Gibson, also known as Just Vibes, on July 22nd, 2022. After July 22nd, 2022, I received no other additional lyrics or modification to the original lyrics from Durk or anyone else. Now, thereafter, I incorporated Durk's verse into the track and finalized the track on my end August 23rd, 2022, prior to the murder occurring. He later goes on to say that, you know what? Also, something that happened was we didn't have the sounds of Quando Rondo saying no in the background. He says the audio and video featuring the no are not from the original recording and appear to be fan edits. That's actually a major. So what that means to me is that this is the best piece of legal work that I've seen in everything that I covered on this channel. Very impressed by the argument. Very impressed by the supporting evidence and the affidavits to support this argument. Now, this is how it's going to break down. It's going to boil down to this. This is actually a great, very strong argument. Impressed. I think Durk, I got to look to see who his attorneys is, but he had stand-up attorneys on this one. Will he get a motion to dismiss? Or will the court grant his motion to dismiss? Will they deny it, but let him look at the grand jury information to see what facts were given to the grand jury? I don't think he's going to get a motion to dismiss. I think that the court is going to let Durk and his team take a look at what information was given to the grand jury in order to get a superseding indictment which named Durk as a defendant. If the information and facts provided to the grand jury, if the only thing they provided was their version of the facts that Durk committed this murder for hire and then made a song about it, there's enough facts in this affidavit to prove that that song was made before the murder, and then the court will have no choice but to dismiss it. But if they get a look at the grand jury material, the facts that were given to the grand jury, if the grand jury got 7 pieces of evidence in this recording, this song was only 1 piece of evidence, even if it's proven that that's false, the other facts may be strong enough to sustain the indictment on Durk. But I think he's got a great argument. It's going to be interesting how it plays out. That's my take on it. Y'all let me know what y'all think in the comments. I'm probably going to chop this up because we talked about some interesting stories tonight. As always, I'm very grateful, appreciative of everybody. Yo, thanks for tuning in. Y'all take care. Be blessed. Have a good one. Peace.